just going to quickly introduce our two guests, both from Osborne Clarke, which is a different solicitor from the last time we saw Jonathan. So, but we move on quickly. But today we're talking about the cyber landscape, and it's an interesting one because Jonathan came a few years back and did a landscape, and I looked at it the other day just to see how we were doing, and yeah, sadly your crystal ball worked. So I'm interested to see what happened today. But Jonathan's a specialist data protection and privacy lawyer. He advises clients across a broad range of sectors. So we're in for a treat because that will be quite an interesting thing at the moment. If he got it all right last time, what's going to happen this time? And we have Peter, who also works at Osborne Clarke as an associate, and he gets involved in commercial disputes. So that's the sort of area that I used to get involved in when I was in insurance. So yeah, perhaps I won't talk to you. Anyway, he specialises in cyber incident response, which is, to me, the best thing around, because we need people to actually help you get through these, not just technicians, but also people on our side of the neck, where they have to deal with the aftermath, not necessarily just shutting the technology down, but what do you do legally after that? And that's quite an important area and often forgotten by all of us in the IT arena, because all we're worried about is shutting it down, protecting it, and then your job's done. So we're in for a great time, and thank you guys for coming along. Not so many in the room, but lots online. So hopefully that will be good for you anyway. I'll leave you to give us the bad news. Thank you.
That's great. Thanks, Paul. Thank you very much for that kind introduction. It's great to be here. Not very many of you in the room, but I'm speaking loudly and projecting because I know hopefully there's a lot more online. As Paul said, my name's Johnny McDonald. I'm a partner with Osborne Clarke, which is a different firm from when I last addressed this group. Great to be with this firm. We've really big kind of European and global to an extent kind of presence. So 25-year offices, big European footprint. This was kind of the reason I moved. So quite an international look. And as Paul mentions, my focus is on data, but that obviously encompasses lots of other areas as well. So infotech, technology by itself, obviously digital regulation, AI, and now cybersecurity. For the next 40 minutes or so, we did have a couple of slides where we're going to kind of promote a bit more interactive discussion. I don't think we'll be doing that this time around, so we'll probably be cutting the session down slightly, which may be welcome news for lots of people. But what we're going to be talking about for the next 40 minutes or so is cybersecurity, navigating the developing legal landscape, and it's a timely topic. In July 2024, the new Labour government announced plans to introduce a cybersecurity and resilience bill. Peter is going to be talking about that in a bit more detail in a moment. And it's interesting because this really is a theme that we are seeing on that legal landscape, whereas cyber used to really sit under the umbrella of data law and a couple of sector-specific laws. Now we are seeing in the UK, we are particularly seeing in the EU, which is very active in the regulatory regime, and internationally, cyber laws standing up on their own 2 feet. And I think that's probably going to be a theme of what we're going to be talking about. But obviously, what we have at the moment, before the new laws come into force, certainly in the UK, there is no go-to piece of legislation. It is a bit more of a patchwork. So we'll be looking into that in a little bit more detail. And with a big caveat at the moment, this isn't comprehensive 40 minutes. There are so many laws touching on this space, kind of existing and new. It is more of a snapshot, taking you through some of the kind of key developments. Now, I say it's timely because of the new regulatory regime we're seeing. It's also timely because of, now more than ever, cybersecurity is key to businesses, and the repercussions of getting this wrong can be big. So that's timely now. That's been timely every time anyone has spoken about this topic for the last 10, 20, 25, 30 years. Anyway, so what we're going to be talking about in terms of content, threat landscape first, so a bit of scene setting. We're then going to talk about the current regulatory landscape, a bit of future gazing then, probably a little bit less kind of crystal ball gazing because we have some certainty. We know some of the laws that are coming down the line. We're then going to be looking at some of the extraterritorial rules that may be affecting people in this room or in this virtual room. I'm going to talk about artificial intelligence briefly before kind of tying this together with some of the more kind of practical steps in terms of cyber risk management. So Peter, turning to you to kick us off, please.
Sure. So it's probably worth briefly setting the scene to talk about the kind of threats that some of our clients are experiencing and the kind of impact that they're actually having. It'll be no surprise to anyone that ransomware is top of the list here. There's still significant amounts of money for threat actors to make here. Some estimates suggested that there was around $1.1 billion of ransomware payments in 2023, and that's before you even start getting into things like fraud and some associated issues there. Many organisations obviously have recognised that risk, they've fortified the defences, but similarly attackers have continued to innovate, they've continued to develop their techniques. And while we once saw purely encryption, and then we started to see encryption and exfiltration and the threat of selling or publishing that data, methods are continuing to develop to apply additional pressure, and we're starting to see increasingly triple extortion. So that's where a third layer of pressure is being applied. And that could be a number of different things. That could be the threat to launch a further attack or the threat to launch a DDoS attack against victims' infrastructure. There's still a lot going on there. It's not gone away. It does seem to go up and down in waves in the media. And likewise, we're still seeing an awful lot of phishing, and business email compromise attacks. They can seem perhaps a little more innocuous than a large ransomware attack. But I wouldn't doubt the significance of them from a legal and regulatory perspective. And they do unfortunately have a disproportionate tail end in dealing with the aftermath. And again, as I say, there were lots of news stories about things like big ransomware attacks. But we shouldn't forget about some of the more quotidian, the more day-to-day threats that people are facing. And that is things like insider threats, where people are stealing data or doing various other things within their organisation. But likewise, it really is still things like laptops being left in taxis and folders being left on trains. And again, they shouldn't be forgotten about within the wider landscape, because they do have significant effects for the organisations that they impact. So what is that impact? What does that look like? Well, each of those things and the various other different threats that exist have the ability to impact how businesses conduct themselves. All of those things can result in claims, and those claims could come from a number of different sources. They come from the individuals. So if we're talking about personal data, for example, there are claims from individual data against data controllers. And likewise, there could be contractual counterparty claims, or there could be you yourself, if something's gone wrong with your IT infrastructure through a supplier, you could be initiating claims yourself against your providers. And throughout all of this, there's regulatory risk. And you may be familiar with the ICO, the data protection regulator, but we also need to be aware that there are sector-specific regulators that apply for different regulations in the different markets in which you operate. And equally, this can be cross-border as well. So you can actually be dealing with scenarios where you deal with multiple regulators across different jurisdictions. And then, of course, reputational impact. If these sort of issues become publicly known, and particularly serious things like ransomware and particularly where there's exfiltration of data, that can have a massive impact on the reputation of a business. And likewise, if you yourself are processing data on behalf of a third party, so if you're a data processor, for example, that can have a massive impact on their business as well. So you could potentially be facing claims and obviously potentially the loss of future business with that supplier. So, sorry, I've skipped a slide there. So to give you an example of some of the sort of things that we've seen, MoveIt was really the biggest attack last year. And why was it the biggest attack? Well, it was because it was a file transfer software that was impacted, and that itself was used by multiple organizations who themselves had hundreds, if not thousands, of customers. So as a consequence, while there were probably about 1,300 businesses that were directly affected by that attack, there were then tens of thousands of customers and millions of individuals who were ultimately impacted by that. And it's a great example of demonstrating how you need to be aware of your supply chain risk as well. And there were quite a few attacks like that over the past couple of years, where it's digital service providers, managed service providers that have links with multiple clients, and the impact if they're hit can be much more significant. And again, as you see on the screen, the cost for organisations who are dealing with this, it's significant and it's increasing. So within the UK, the estimate is that it's about 4.5 million for a data breach. Now, in some cases, that can be much more significant depending on the size of the breach.
Are you okay to take a question?
Yeah, go for it.
So Move It, I happen to know from a technical side, was a SQL injection attack, and it's a very long-standing, and it involved Progress Software, which are a reputable firm. However, Progress Software as a company didn't seem to suffer noticeably from. So, do you believe that there's going to be any kind of statutory basis for vendor liability, where instead of vendors just putting out software that's got a SQL injection vulnerability, everybody else suffers? They don't suffer at all. It's the kind of moral hazard thing that's been argued that there should be liability on vendors not to put out insecure products, and really to do a lot better job on the technical security of the products they ship. Do you think that's going
in short, probably there's going to be something there, and we'll be covering that. So there's we'll be covering in a bit. There's the Cybersecurity and Resilience Bill. Details on that are quite thin, but I would anticipate that it's going to be targeting essentially lots of different kinds of digital service providers who are effectively that link in the supply chain, one removed, where you're going to be having an impact. What the extent of that's going to be, I don't know. I suspect it's probably not going to go quite as far as you're suggesting, but it may mean that at a minimum there are going to be an increased number of digital service providers who fall within scope of regulation and who are subject to much more stringent requirements.
I suppose where I'm seeing it from is like, CrowdStrike was a leading cybersecurity, and then it called it, but actually really nothing much happens to the vendors. Keep on still selling. They keep on, maybe sometimes their share prices go up because more people get to hear about their software. So effectively, there doesn't seem to be any incentive mechanism to sort of like. And Microsoft has said that they're going to prioritize security. Satya Nadella said, going to prioritize security, and I'm going to not take 50% of my pay because of our security. But actually, Microsoft is even now promoting bad security practices. So we don't really see any kind of change in the behavior of vendors. They still keep pushing effectively insecure products.
And so just on that, well, I mean, one of the ways that you bridge the gap is by the kind of requirements you have in your contract. Even said and done sometimes with bigger, you may be breaking those standard terms, but otherwise that's where you try and, as a recipient of those services, that's where you try and protect yourself a bit more through those contractual measures.
So I just wanted to add to that is that obviously the very big providers, they actually have very good standard terms in terms of reliability issues, but even in like medium to still large scales, you got to work with the standard contract. And as a company, if I buy this product to ensure that I'm not into because at the end, even though my airport was down, I'm still the liable because the flight didn't leave, right? And there's currently no regulatory framework to say that okay, this failed because of that product I'm using. And obviously this impacts everybody on a global level. So even if the UK Parliament regulates that, that's great for UK customers. But if I contract with a vendor from the US, then I'm still in the very same issue.
Yeah, it's a really good point. Just kind of building on Peter says, I think the way the regulators looking at it is obviously, they try, especially the EU, they have laws that have extraterritorial effect. That is always an issue that businesses are going to face. Certainly we're seeing with the new regulations we are seeing in DORA, which we're going to be talking about in a bit more detail in a bit. That is one of these laws that is alive to that risk. And what that does is it imposes additional obligations on the service user, on the financial institution. But what it also does is it mandates kind of provisions that need to go into those contracts. And why does that help? Well, it helps you say, you know, as you say, the kind of, you know, the small user, the medium user, the SME who doesn't quite have the power to negotiate with Microsoft says, well, you know, look, your standard terms are no longer lawful in the EU, so you need to, so it gives you that kind of bit of clout. So absolutely, probably is no easy answer, but as Peter says, kind of contractual obligations are helping in this space.
Can we just see if there's any questions online? Steve?
Just one comment there from Fox. Consequences for vendor breaches should be in all our contracts. But for the end user, also often us, we need some redress. So it's exactly.
Moved up that point. Yeah.
Thanks, Fox.
Thank you.
I think we're done. Let's move on to the next section, which is taking a look at what the current regulatory landscape is looking like. So Johnny is going to take us through that.
Thanks, Peter. We're not going to spend ages on this. Obviously, you know, the slide on there is talking about the GDPR, the UK GDPR, the Data Protection Act, those kind of provisions. It would be remiss of us to talk about any kind of cyber security presentation and not mention the GDPR. It's very well established. It is widely adopted, so people are familiar with it. The security obligations under the UK GDPR, as people are familiar, so to give us a reminder, they relate to more than just having appropriate technical and organisational measures in place. Now, obviously, in terms of those security obligations, kind of the market has developed certain standards. That's great. But the other thing the UK GDPR does as well, it was the first law that brought in substantive data breach notification provisions. So that's one of the kind of key things the GDPR kind of moved the dial on. So just touching on that for a moment as a way of a reminder rather than anything else, personal data breach. So breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure or access to personal data transmitted, stored, or otherwise processed, or to give it a more workable definition, a security incident that's affected confidentiality, integrity or availability of personal data. So that's the kind of issue that people need to be aware of, and we are still spending much of our time discussing, okay, well, you know, what is personal data? Is it involved in some of these kind of complex kind of data breach kind of events? There's still discussions about kind of liability in this space. But in terms of the notification requirements, as a reminder, the processor, their obligation is to report breaches to the controller without undue delay. As a controller, your obligation is to report breaches where feasible not later than 72 hours after determining that a breach has occurred. And just on that point there, that idea of determining when the breach has occurred, well, you have a reasonable, you need to have determined with a reasonable degree of certainty that the security incident has led to a personal data breach. So you have a bit of a window. It isn't quite the kind of the inflexible 72 hours that was first thought of when the GDPR came into force. Once again, that kind of requirement, it's not that you must know that kind of beyond all reasonable doubt, you know, it must not be kind of absolutely certain, but you must have a reasonable degree of certainty that the clock has started ticking. So that's the UK GDPR DPA. Data breach notification regime.
And just by way of addendum to that, we've got the Privacy and Electronic Communication Regulation, sometimes referred to as PECA. You hear about the e-privacy regulation. This regulation sits alongside the UK GDPR, and what it's aiming to do is to give individual privacy rights in relation to things like electronic communications. And more often than not, people actually talk about this in the context of some of the other things it does, like direct marketing cookies. But what PECA also covers is the security of public electronic communication services. So think telecoms. It imposes security obligations specifically on service providers, and that's telecoms providers, internet service providers. And it requires them in quite a similar way to GDPR to put in place appropriate technical and organisational measures in order to safeguard that service. And like GDPR, there's also an obligation to notify the ICO in the event of a breach. Unlike the GDPR, though, the threshold for there being a breach is essentially, you know, has there been a personal data breach? There's no seriousness threshold there. So it's very easy if you're within scope to trigger that and to notify. There's normally a 24-hour period in which you need to notify, so somewhat shorter than under GDPR. But having said that, the ICO has indicated that they'll take a slightly more flexible view on that. If you do happen to come across this and you do need to notify, always worth remembering, if you have to notify the ICO under PECA, there's not necessarily the obligation to notify under GDPR because there is a specific carve out for that.
Can I ask a question? Where employers effectively provide to their employees with internet access as part, and the policy says you can make reasonable personal use of your work computer to access the internet. Would you expect the employer to intercept the employee's communications by putting in fake certificates, which I've noticed lots of employers doing? So effectively, the employer is in a position to intercept the communications of the employees going to, whether it's Tesco or their bank or whatever. Very commonplace practice. As far as I'm concerned, that's illegal, but lots of employers do it. Is there anything that's going to happen in that space to actually sort of make the employers responsible for not interfering with the security mechanism? If you look at the provisions in law, obviously you expect that both parties to a communication have to consent to interception. So if you're putting yourself in between an employee in acting in a personal capacity and a third party organisation, you would need to sort of attach something to say this has been intercepted by the employer, but they don't do that. They just intercept and do that, and they're not really covered by the local business practice regulations because they're not doing a determination of whether it's for business use or not business use. They're not doing like a DNS lookup. Is it on this allow list or deny list? They're actually intercepting a communication they're allowing to take place. Do you think there's going to be any change to the enforcement regime in that? Because it's happening all over the place.
It's a really good question, Peter.
I have to say I'm not familiar with any changes that are coming through specifically on that point. I suppose that also comes down to GDPR as well, and whether the employee privacy policy actually has a carve out for that, and because it may be, in some cases there may be instances where that is allowed, albeit with certain guardrails put in place. But I'm not aware of anything that's coming down the line with that. I suspect that would, admittedly, that probably, given that it's got quite a narrow focus, would probably sit more with our employment colleagues. We sometimes deal with this kind of stuff and some of the kind of the monitoring that takes place of employees. But certainly, I can't say there's not, but I'm not aware of anything that's coming down the line.
Yeah, it's a really interesting question in terms of kind of the inception of communications, and interestingly, you say that to your mind it's unlawful. I was thinking, is that the case, or is there some kind of exemption that would apply? But I guess obviously they may not be intercepting the kind of the body, the text, the communication itself, the substantive data, but they may be intercepting metadata. So potentially, I guess the starting point would be that yes, you would need the consent of both parties. So it's a really interesting question.
Well, it's really to do, and again it crosses over into the interference with the security mechanisms that other people have put in place. So if say Tesco or British Airways has put a security certificate on its website, and then that's not the certificate that's presented to the employee, the certificate that's presented to the employee is the fake certificate that the employer has installed in the browser. They've interfered with the security mechanisms of the other company that would have been used to protect the confidentiality, integrity of that company communications, logging in, the passwords. They're also creating a huge concentration of passwords of employees going to all of these different organizations. It's not good security practice. I mean, it's actually, but it's a widely practiced bad security practice, because people just think, oh, well, we need to be able to do data loss prevention, therefore whack in a piece of technology that will do this, but they don't think about the legal implications of what they're doing.
Yeah.
Feels like there's a whole debate around that interesting.
Anyway.
Just before we go on though, I've got a couple of questions coming through here, if you're okay.
Of course.
So Fox was asking, coming back to GDPR, she was asking whether you think there might be, let me just turn back to the...
About the EU adequacy, do you think there's any risk of the UK losing
risk of losing adequacy?
assessment?
What is this in
EU
response to the
adequacy.
data use and access bill, is it?
No. So you know that obviously when you're doing international transfers,
Yeah,
the EU make adequacy decisions about whether the laws of the countries are suitable for international transfers. And at the moment, the UK's got an adequacy decision, but if we diverge too much from EU law, allowing other uses of data which other EU countries wouldn't do, then we could potentially lose our adequacy assessment. Yeah.
Let me read the question. What is your opinion on UK's current GDPR data protection adequacy? Do you think this is still at risk of UK losing this for the EU?
Yeah, it's a really good question. So at the moment, as it stands, I think that because obviously this is such a political question as well as a legal question. There are no substantive changes planned, notwithstanding the new data use and access bill, which we are going to see in 2025. Another law that I said this was a snapshot we weren't intending to talk about just because there's so much to talk about. But even with that in place so far, there's probably nothing kind of legally that the EU would be able to certainly kind of hang their hat on and say, yes, you are going to lose adequacy over this. Obviously, we are seeing lots on the kind of political development at the moment. One of the issues being the kind of the new Trump administration and whether there's talk about him potentially kind of rolling back some of the kind of, the data transfer mechanisms that apply for the US. And therefore, do we get back into that question that, okay, is the UK a backdoor for US data transfers? And with the EU politically not like that? So that is probably the more kind of medium term space to look at, as opposed to thinking, okay, are there any particular regulations that the EU really doesn't like at the moment, notwithstanding the fact they are due to review the adequacy in the next, 18 months or so. But yeah, really good question.
Thank you, Paul.
Excellent. Okay, if there's no more questions at this point, we've covered the UK GDPR and PECA, which very much had a personal data flavour to them. There is other UK legislation which has an impact on cybersecurity, albeit not specifically focused on personal data. One of the most significant pieces there is the NIS regulations. And the NIS regulations applies to only certain sectors within the economy. And it was intended to introduce a kind of baseline measure to protect certain sectors which were seen as being particularly important to the economy. And therefore, if they were impacted by cybersecurity incidents or security incidents in general, there was going to be a much greater impact. And the kind of areas in which that applies, it applies to two broad categories. The first is operators of essential services, and that includes things like energy, transport, health, water, and it also applies to digital service providers and various digital infrastructure providers as well. It's got, at a high level, it's got a similar security obligation to GDPR and PECA, albeit because of some nuances in the wording, it's slightly more onerous. But again, it requires providers organisations to have appropriate and proportionate technical, operational and organisational measures to manage the security of network and information systems. NIS also has a bit more of a resilience angle to it as well. It's not, strictly speaking, just cyber. And I say that because it requires in-scope organisations to prevent or minimise the impact of incidents. So this is where things like CrowdStrike, for example, which wasn't a cyber attack, potentially come within scope of something like this. There's the obligation to notify under NIS, and the regulator will depend on the different sector you're in. So, for example, if you're in energy, for example, it might be Ofgem and/or the health and safety executive. If you are a digital service provider, it's probably going to be the ICO. And again, under NIS, very much like GDPR, there's some significant fining powers. So if you get it wrong under there, you can be subject to some pretty stringent fines. Though, to my knowledge, in the UK, I don't think there's actually any fines under NIS. So that's NIS. We'll come back to some potential changes to that regime, both in the UK with the Cybersecurity and Resilience Bill and in the EU, but I'll just park that for the moment. So next, we have the Telecommunications Security Act, and that's updated the Communications Act 2003. What that was focused on was setting out some legally binding minimums in relation to 5G and full fibre networks to protect the UK telecoms network from cyber threats. While it's directly targeted at telecommunications providers, it also can have an impact on those in the supply chain indirectly because of the contractual obligations that are expected of the telecoms providers. Again, in this case, if in the event of a breach, you need to notify Ofcom and potentially anyone else who's been affected by the incident as soon as reasonably practicable. And there's a general duty in relation to security there, which is made up of 3 parts, and that's to take measures to identify and take measures to reduce the risk of security compromises and to prepare for their occurrence. And that's just a very general, very high level security requirement there as well. So, Jeremy.
Brilliant, thanks, Peter. So there's a theme to some of these kind of new laws that we're going to be talking about, and that is the fact that there are more prescriptive requirements. So there were just 2 other kind of regimes that I wanted to briefly mention on this slide. You know, there's probably others we could have spoken about as well, but the first one being kind of financial services, so the FSMA, and then secondly the new product security telecommunications infrastructure regime. So firstly, the FS regime. So cybersecurity falls within the FCA's wider operation resilience requirements. There may be some on this call who are very familiar with this regime, and the overarching goal of this is to strengthen regulated firms, those firms within scope, their resilience to the impact of operational disruptions caused by cyber incidents. So just to very briefly talk of what the FCA regime, the FSMA regime looks like it. Well, firstly, the requirements are principles based. There are 12 principles under the FSMA that regulated firms must adhere to. A number of these touch on cybersecurity, but one, principle 3, is considered to be key, which is a firm must take reasonable care to organise and control its affairs responsibly and effectively with adequate risk management systems. So that's the overarching principle, not dissimilar to the UK GDPR regime that we are all familiar with. Principles, more prescriptive rules sitting underneath that. So underneath the principle, you have these more prescriptive rules, and then translating those, you have the regulatory guidance, which translates into more practical steps. And in the cyberspace, they encompass things like governance, risk management, incident management, resilience, third-party management, training, technical controls, and continuous monitoring. And just to give an example, just to give a snapshot of where we're talking about these more prescriptive regulatory requirements, for example, regarding monitoring and reporting under the FSMA, there is obligations to monitor systems and networks to detect and respond to cyber threats, and as well as there are reporting obligations to the FCA as well. And useful to kind of call this out because it probably gives us an understanding of the direction of travel in this space as well, these more prescriptive requirements. The FCA has been a first mover in this space for obvious reasons, and they are a regulator with teeth. And then secondly, just talking about briefly about another example of more sector-specific cybersecurity laws. So a newer law, the Product Security Telecommunications Infrastructure Product Security Regime, first elements of which came into force in April 2024. And this applies to smart devices, think the Internet of Things. So consumer connectable products, so, smart TVs, smart fridges, wearable tech, that kind of thing. And this too has some really prescriptive requirements, which were probably talked about in the general press when the regime came into force. So things like unique passwords. So all consumer connected products must have unique passwords that are not resettable to universal factory default values. And the list goes on, kind of vulnerability disclosure policy, manufacturers being required to have specific policies in place, security updates, prescriptive requirements that apply in this area here. And this is the direction of travel which we are seeing. Once again, regulatory enforcement teeth behind this regime as well, with a number of regulators potentially with authority to take regulatory action in this space. And then just to finish off this section before we move on to a bit of kind of crystal ball glazing and looking at what's coming further down the line, just a few other considerations that are driving cybersecurity developments as it stands under the current regime, as of today. These are fairly obvious. So insurance contractual requirements and the requirements of the PCI DSS regime. So in terms of insurance, obviously there are prescriptive requirements in place. You know, we just pulled off an example of the type of security wording that you are seeing in policies. So you must ensure that all remote privileged administrator, custom and supplier access to your computer systems included but not limited to any virtual private network and cloud-based email services is secured by multi-factor authentication. Really detailed prescriptive requirements. Contractual requirements as well. Obviously, we talked about this earlier on, this kind of idea that, okay, well, in some cases, can the major suppliers, can they sit behind their kind of the fairly generous terms, where they probably have exclusions, limits of their liability, which means they don't suffer so much in these circumstances? Well, yes, that's true, but there are contractual requirements that can apply, and they are kind of worth noting. And then PCI DSS, we don't have time to go into that at the moment, but once again, prescriptive requirements, potentially reporting obligations, and potentially kind of serious consequences if things go wrong under that regime as well.
Well, just ask a quick question.
Yes, of course.
From an insurance perspective, you'd expect me to ask this question. Where I was interested in recently was I was talking to somebody that said, "Oh, I have cyber insurance, and therefore that protects me." And the salesperson was selling it on the basis they had a cyber policy, and this is a friend of mine, and they were sort of saying, "Well, that's great, but the salesperson doesn't know what the insurance policy says." Are you seeing that generally, or you're saying about that you don't, you know, the person who is actually going to buy your product may not necessarily know that your insurance might not cover it?
Yeah, no, absolutely. It's a really good point. And it's one of the kind of, whenever clients come to us and say, we think we've suffered a security incident, one of the key things, the first thing you do is you refer them to the wording of that policy, have a look, because, there may be limitations, there may be things that you need to do now, conditions, precedents, to make sure you don't kind of breach that. So yes, people probably aren't as familiar as they should be with these policies. I'm not sure if you're into that, obviously you deal with this kind of thing, all the time.
I think you're right. I'd make one point first of all. I don't think if you're selling yourself on the basis that you've got cyber insurance, that's great, because that's suggesting that you're expecting something to go wrong. But
That's a good point. Thank you.
If you do have a cyber insurance policy, the coverage can be completely varying in terms of what's actually in scope. Is that going to cover things like a ransom payment? Is that going to cover things like the different providers that you can get in? So the lawyers, the forensic investigators, the PR professionals, everyone who in a big incident really is required. Also, you just don't know what the cap is. They may have it's expensive generally. So you don't know whether they've actually got something that's going to be comprehensive. You also don't know in that scenario whether you would be the only person impacted. If there were hundreds of other clients as well, then really, how far is the coverage going to go? And another point I'd make, and particularly with the excerpt from the policy that Johnny mentioned there, if you have similar conditions within a cyber insurance policy, and they tell you to do something like have in place multi-factor authentication on X, Y, and Z, or if they say have appropriate regular backups, if you fail to do that, then potentially it might not cover you. Or you can find yourself in a really awkward position where you're trying to engage people like the lawyers, forensic investigators, and what have you, and you're getting several weeks through the investigation and through the incident response, and you're still not entirely sure whether you're going to be covered for those costs, because there's a bit of a question mark about whether you have crossed the line there. And insurers will often allow clients to go through that process, saying, look, in principle, go through it, but we're reserving the right to be able to deny coverage here. And that's a really awkward position to put someone in, because you're accepting things that you may then not be able to afford if the policy doesn't apply.
I completely agree with what you're saying, but just from a recent, a couple of years ago experience with a client, there's also the issue of the period that you need the support. So most incident response, like sort of Mandiant, will say, well, we will only sell you a year of post-incident cover. Now, the insurance cover might say, well, we'd be quite prepared to give you a few weeks of cover. We're not paying a year. So you've got that gap between what the insurance would consider reasonable is, a bit of support post-incident, and what you get from the market, which is, oh, the minimum period you can get is like a year's post-incident, and that just companies don't realise that they need to fund that themselves. They've got to have those reserves to cover the full post-incident period. Yeah,
and there can be gaps as well. So if you may have an excess, for example, if you're talking about notifying individuals, if it's not over a certain threshold, well, they might not cover that. You might have to pay an excess. So there's a whole range of issues like that you can be caught out. But the key takeaway for that is speak to your broker. Go through the process, work out exactly what the coverage is, because clearly not all cyber insurance policies are created equal.
This whole thing's still evolving, isn't it? Can I just chip in with a couple of comments from online, just so that we can continue to involve all of them? So from Fox, I think this is, gosh, it'd be fantastic to have all these bits of legislation mapped, so we can more easily see some key controls going into which match requirements in which bits of legislation. So, what do I need to do to address these things in this legislation, these things in this legislation, to protect myself against these things going wrong for us? And then a follow-up question with the NIS regulation. So NIS 2 is coming. In your opinion, do you think we'll go the way of NIS 2, presumably the UK, and have external companies certifying companies that come into scope? Or is your opinion that the UK will stick with the ICO and the DFT as auditors, etc.? What are we doing with NIS 2?
Just by background for anyone who doesn't know, we will be covering NIS 2 very shortly. NIS 2 applies it's in the EU regulation, came into effect on, I think it was the 17th of October. Having said that, many of the member states haven't actually implemented it yet, and are making varying progress in terms of their level of implementation. It builds quite significantly on the original NIS regulation, which applies in the UK. Will we go that far? I don't know. That's going to really be a case of what's covered in the Cybersecurity and Resilience Bill. Hints were given within the announcement of that bill in the King's speech, suggesting alignment with the EU position. Whether it'll go that far in terms of external kind of accreditations and things like that, I don't know. If I had to guess, I think it will probably just expand on the current regime, and you'll probably find this will have sector related reporting for most things. So if before you were covered by Ofgem, we have that as well. If you were the ICO before, probably again. What you may see though is an additional layer on top of that of reporting of certain incidents. What those incidents are, unclear. Probably includes ransomware attacks, but that could be to anyone. That could potentially even be to someone like the National Cybersecurity Centre. And I suspect, based on previous consultation and information gathering exercises run by the government, it's probably that the government wants to know what the scale of the problem is, rather than trying to make some additional reporting requirements.
Interesting. And interestingly, BCS has been promoting that whole idea of greater governance, greater visibility, greater reporting, because the truth is we don't really know the scope of the problem because we haven't got the reports to tell us. So chicken and egg there a little bit.
And Steve, can I just come in, because that first question, I could have planted that myself. So that idea of kind of mapping out what these requirements are, we have actually OC, and I'll share this with Steve and Paul, but we have a digital regulatory timeline. Obviously, it doesn't go into the detail of kind of mapping out the kind of the prescriptive requirements, but it goes some way to give a snapshot, because this is such a complex and evolving area at the moment, with new competing in places laws coming into force all the time. So actually, it's a really useful tool that we've developed. So yeah, you'll have Peter and my kind of contact details in this, and also I'll share the link as well.
Yeah, we'll post that out.
Brilliant.
Thank you.
Conscious of time, and we've still got a fair bit to cover, which we're going to race through, so at least we kind of cover some of the substantive elements. This was going to be a slide where we're going to stop and say, okay, any comments, any surprises? These are some of the kind of practical requirements which we are seeing in terms of how the ICO approaches this, in terms of other kind of market developments. But we'll move on from this slide now, just so we can keep on going, and we're going to move on to now, and as Paul said, when I last did this, it was a bit more kind of crystal ball gazing, whereas that's not the case with this talk, because we have an absolute runway of legislation which is coming down the road in the coming 12, 24 plus months. So moving on to that, Peter.
So this goes to the UK position in terms of really the NIS regime. The Cybersecurity and Resilience Bill, it was announced in the Labour Party's maiden King's Speech. It's really driven by recent attacks on important organisations throughout the economy. Think about things like Royal Mail, British Library, infrastructure supporting the NHS. They're not necessarily actually covered by the NIS regime, even though they are obviously critically important. And that's broadly what this bill seeks to address. As I mentioned before, it seeks alignment with the EU. So what do we know? It's, as I say, it's very thin on detail. It is hinting at broadening the scope of the existing regulatory framework to cover more digital services and supply chains. It's a bit fuzzy on detail there, but if we were to look again at the sort of consultations that the previous governments are running, that probably is going to be looking at things like managed service providers and various other digital service providers. Again, the sort of people who are the linchpins within the supply chain and who, if they're impacted, can impact multiple other organisations. It's also looking at enhancing the authority of regulators to ensure that security measures are actually being enforced. One of the problems with NIS is that when they actually did the post-implementation reviews for that, they found that a small number of organisations, I think, by the time of the second review, only about half of organisations who were subject to this actually made any changes as a consequence of it, which is somewhat worrying. So they're looking at a kind of more proactive enforcement regime for that, where the regulator could potentially proactively investigate organisations' compliance and potentially can gain funds through cost recovery mechanisms. Again, what that means is to be determined. There's also, as I mentioned before, the potential for some level of reporting requirements. I suspect, given that NIS already has reporting requirements under it, that this is probably something like reporting to the National Cybersecurity Centre for information gathering purposes. In terms of timing, all we know is that it's going to be introduced to Parliament next year. So, quite a message going to come in is anyone's guess. As I say, detail very, very thin on this, but it's one to watch because it will expand the scope to different sectors, to different kinds of organisations, and it will potentially expand the kind of obligations that you're subject to, and particularly if it echoes NIS 2. Very briefly, just mention that these exist. The government has introduced a couple of cybersecurity codes of practice, 2 of which have been published, 3 of which were in the consultation phase around the time of the new government coming in. Johnny's going to actually talk about the cybersecurity, the AI cybersecurity kind of practice a little bit shortly, but broadly, what they're all interested in doing is providing baseline cybersecurity measures for the organisations which come under the scope of the different ones. So the Internet of Things guidance, for example, has some reasonably prescriptive guidance on some of the things you need to put in place there. Quite what the status of those is going to be is unclear. Under the previous government, they were suggesting that they're voluntary for the time being, but they were going to consider whether they would form the basis of some kind of regulation. What that's going to look like with the new government, we're going to have to wait and see, really. But it looks like the top 3 that are noted on the slide are just chugging through. So again, just keep an eye on that.
Brilliant, thanks, Peter. Next slide, please. So just talking briefly about DORA. I'm conscious of time. People don't want to listen to cybersecurity talk from 2 lawyers for more than an hour and probably for slightly less. So we're going to try and race through some of these last bits. So DORA, the new Digital Operation Resilience Act, I probably missed this out other than the fact we had some interesting discussion about this before. So it's the new regulatory framework, applies from January 2025. Lots of clients undertaking compliance exercises at the moment. It does come with some kind of key practical requirements. It applies to a range of EU financial institutions, but also importantly to some of those service providers as well. So in terms of the practical requirements of this legislation, you know, they're varied. The specific security measures that it mandates, certain policies and security updates that it needs to be put in place. But one of the key things it does, or two key things it does, is firstly, it requires in your financial institution's contract with its ICT third-party service provider, certain provisions to be in that contract. So related to data location, data treatment, service levels, and various other things. And it also requires certain critical ICT third-party service providers to maintain a presence in the EU themselves, so they can be subject to regulatory scrutiny as well. So we had that question earlier on about this kind of this gap with service providers under certain circumstances be able to kind of evade responsibility. You know, the regulators are aware of this risk.
So NIS 2, again, we've talked around this. I'll try and whiz through this as quickly as I can, but I'll emphasise it is an important change. Why is it relevant if you're not in the EU? Well, like the GDPR and many other European regulations, it has extraterritorial effect. So if you're providing services into the EU, you potentially are within scope of this. And in terms of the organisations that it applies to, as you can see from the middle of the slide there, it applies to a much wider range of sectors. And actually, if you were to go to the regulation itself, there's a couple of appendices there which list all of the different kind of sectors to which it applies. It is much broader than NIS. So there are a whole range of organisations who will now be caught who were previously subject to that. It also is much more prescriptive in terms of the cybersecurity requirements that it imposes. Actually, within the regulation itself, it's got a section that deals with those requirements, and they are minimum. So they are, you know, they're taken as given that you must have those in place, and probably a bit more as well. But for a select few sectors within this, there are also additional requirements for security. So there's a to go alongside NIS 2, there's an implementing act, and that implementing act applies to various categories of digital infrastructure, service, ICT service management, digital service providers, and that provides extremely prescriptive requirements. Certainly, I know when the draft bill came out, they ran to 26 pages, so they are, you know, incredibly onerous for those organisations. What else does it do? It updates incident notification requirements. There's now a kind of 3-tier notification system where you can notify within different periods of time and provide different amounts of information. It also introduces the concept of management responsibility as well. Admittedly, it could be a little bit clearer about what precisely it's getting at there, but really it's talking about management bodies, so probably boards and board level, and it expects them to do things like participate in cybersecurity training so that they themselves are aware of what they should be doing. But it also requires them to assess and approve risk management measures within their organisation. And in terms of how they can be penalised, it's potentially removal from management responsibility for a period of time. Again, it's got a similar kind of regime to GDPR in terms of fining, so that could be quite significant. So I think it's about $10 million or 2% of global turnover, which is higher. And as I mentioned, it is normally in force, but again, the implementation is progressing at different rates. Things to do to prepare if you are within scope, or well, firstly check, are you in scope? Consider registering, because that is a requirement, and consider the jurisdiction in which you're potentially within scope. Because the implementation, although it's supposed to be consistent, there are subtle differences in terms of how it can apply across different member states, because different member states can elect to add certain bits on. And then review compliance with the security requirements. So, have a look through what the specific requirements are, see if you're compliant with that, and make sure policies and procedures reflect those requirements.
Peter, quick question if I may.
Sure.
If you are in scope, who do you register with?
Good question. It will depend on the jurisdiction. who they select to be the competent authority. So
Will be choose your competent authority in the EU.
yeah, so exactly. So if you were in France, for example, they may have again sector related regulators who you would have to. But that's a member state implementation
It
issue.
won't be the privacy regulator, it wouldn't be the CNIL in France or.
Could be if they selected it, but it could be. But it just depends who they choose as the most appropriate body within that state.
Brilliant, thanks, Peter. I'm conscious that we're coming up for time, so I'm going to race through these two slides. So we're just talking about some kind of other regulations that impact cybersecurity indirectly. Of course, the EU AI Act, we'd be remiss for any technology talk in 2024 not to mention that. So trying to say, first, comprehensive legal framework. We know it is going to be affecting a lot of businesses, a huge extraterritorial effect. Categorizes AI systems into 4 categories: unacceptable, don't do it; high, limited, and minimal risk, and then it imposes obligations off the back of that. In terms of cybersecurity, unsurprisingly, like with lots of other provisions of the Act, it predominantly bites on those high risk applications, and some of the requirements are fairly prescriptive. They're still developing. We're still waiting for kind of more detailed guidance from the Commission. That will be coming in the coming months. But essentially, what they are looking to do is taking kind of fairly established cybersecurity requirements and standards and applying those to AI-specific vulnerabilities. And some of this kind of wording like data poisoning is going to be a new lexicon for those who are familiar with cybersecurity who aren't yet familiar with AI. And then in the UK, really briefly, previously we thought we were going to have a wholly principles-based regime based on the existing regulatory powers that various regulators in different sectors have. King's Speech, new government. We now think we are going to have a more formal legislative framework, which will probably bite on the most powerful AI models, whatever that may mean. But we are now going to have a degree more formal requirements under the UK regime as that develops in the coming months and years. In the meantime, what we know that we do have, as Peter's alluded to, is there is an existing consultation for an AI security code of practice. This was published back in 2023. It's been out for consultation, and what they are looking to do is probably kind of close that consultation in the kind of coming months, and then develop and update that code of practice off the back of that consultation feedback.
Great. Just finishing off. So I think there's many people in this room and on the call who will be much better placed than Johnny and I to talk about the sort of technical measures that are relevant to a given organisation. But it's also worth just mentioning that cutting across all of these different regulations, there are some fairly consistent strategies that will apply generally and we can reduce risk. So I'm going to quickly go through them, but I'm certainly happy to open it up to the room or online for anyone's thoughts on key risk reduction strategies. Firstly, due diligence and conducting audits. I would encourage anyone to undertake appropriate due diligence on third parties prior to contracting. And again, easier said than done sometimes if if we're talking about some larger providers. But it allows you to at least assess, have they got appropriate measures in place to ensure security for your organisation and, indeed personal data if that's relevant. Understanding your data, data mapping, understanding exactly what you have in your organisation. That is, again, easier said than done. There are black spots within any organisation where you just don't know where data is being held, where it's being processed, and indeed which systems are being used. Somebody has decided to download a particular bit of software, could be Move It, for example. You don't necessarily know who's doing that and what data is being processed. But trying to gather that information together, trying to have a holistic understanding of where your data is, where it's stored, who it's being shared with, is a great first step to being able to make sure that you can secure it. Data minimization and retention. Again, this is classic GDPR requirements. But it's important to think about, how much data are you having? are you storing, and how long are you retaining it for. If you can reduce the amount of data you have, and if you can reduce its retention period, if the worst should happen, then that potentially reduces your risk and reduces the risk to those people whose data you're processing as well. So it's a really simple thing to be able to do. But again, it's an area where a lot of organizations fall foul. And when we're helping people through cyber attacks, we often find that there are pockets of data where they've forgotten about them, and they might be holding on to it for 10, 15 years, far in excess of what they should have been. Minimal contractual measures, we've touched upon this a number of times, but trying to put in place minimal contractual measures to make sure that you protect yourself. Some of which are mandated by different regulations, including GDPR, for example, when engaging a data processor. But having a think about some of the other protections you can have in place, thinking about the extent that you can negotiate these things like liability caps, making sure that there aren't any exclusions for data incidents, cyber incidents, and that sort of thing. And then data security. It's all very well having policies in place which map to the different regulations, but there needs to be clarity within the organisation about how those technical and organisational measures are actually being deployed in practice, and making sure that everyone knows what they should be doing. Critically, if you have those measures in place, do document everything. Don't just put them in place and then not have a record of that, because if you need to account for anything to the regulator, then you need to have it written down somewhere. And finally, insurance. We have covered this, but worth emphasising that cyber insurance is available. It can be valuable. It provides potentially a whole range of different things, such as covering any financial loss. So if you've got a business interruption, potentially even ransom payments, and critically, they could potentially provide third-party providers. So that's, as I say, specialist cyber lawyers. It is PR professionals. It's ransomware negotiators who can actually engage with the attacker. It includes forensic investigators who can, make sure that things are closed off. So it's worthwhile considering cyber insurance if that's something that your organisation hasn't already considered. And with that, I think we're done with the substantive content. But obviously, if anyone's got any further questions, then please.
There was a question online. Any idea how the right to erasure will work in AI?
It's a good question.
You know what, that's a real, to be honest, my kind of closing thoughts on this talk were going to be the fact that, obviously, kind of thank you for engagement, to also say horizon scanning at the moment is a job in itself. We just don't know. We can kind of predict. We're waiting for regulatory guidance. We're waiting for market practice to develop. There are really detailed questions like that at this stage, we simply would be speculating. It's a great question. We don't know, kind of watch this space.
I've got another question, okay, which is really about the shift towards things being purchased as cloud services. And with cloud services, there's this blurring of the lines about what technology is it actually involved, so you buy a cloud service, but you're not necessarily like saying, oh, it's going to be behind the scenes, it's technology, all that technology, it's been abstracted away from you. And very often the nature of the cloud service, they talk about evergreen, it's going to change, and it's going to change without any change the contract wording. It's going to change. It's just going to evolve. It's like, oh well, we decided to put this inside, and there won't be any paperwork. There won't be any independent tracking of what's changing. It's just going to evolve. And effectively, what I see with the cloud service providers, they're almost like acting like software drug pushers, where they're constantly adding new features, and like you take Microsoft, oh, you're on Microsoft 365 subscription. Oh, we're now going to turn all of your staff into citizen developers, and we're going to enable Microsoft Power Platform by default. And no, you can't turn it off because we've deliberately designed it so you can't turn it off. So you get all these situations where effectively boundaries of what you're getting are being changed by the service provider's conduct without any changes to the contract, without any changes to your agreement. It's basically you're having technology pushed on you. And I'm interested in what as lawyers, is there anything you can do to help companies to say, actually, no, you're not allowed to change, you're not allowed to add new functionality, you're not allowed to push things on us because we want prior consultation, we want agreement, we need features to be able to be turned off, we want to apply data minimization, we want all these things, and actually you as service providers, you can't expect to do that to us.
Yeah, no, it's a really good question. Peter may have some thoughts as well. I'll take this first as the commercial lawyer. So I'll make a few points. It's an interesting kind of position that you articulate, and that's sometimes the way it is. But certainly with the hyperscale service providers, they will provide this with as is. What I'd say, and generally, once again, with the hyperscale service providers, you're going to have certain protections in there. So yes, there will be provisions like that, probably hidden under the umbrella of continuous improvement. Okay, if that is improvement, that's kind of fine. You need to make sure that you have the flexibility, and you'll have it within the contract, certainly with the hyperscales, because that's what they do. That if there are adverse consequences to how you use the service, that you will have termination rights. So legally, you'll have a degree of protection there, but it's a really good point. So secondly, kind of making sure that that's backed up with contingency plans as well. So kind of commercially, what do you do if you're using AWS and then suddenly they introduce something that just doesn't work for your business, and therefore that kind of affects you? How can you adapt to that? What does that mean? Does it mean change it to Google? What does it mean? But having those measures in place. And then the second point I'd make is, once again, drawing the distinction between the hyperscales, who will have fairly non-negotiable terms, but will have a degree of protection there. So that kind of next level of service provider, who are resellers or whatever those. Now, sometimes what you find is those suppliers will hide behind the terms. So no, we can't offer this, or we have to do that because that's our agreement with AWS. That isn't always necessarily the case. And to give a trite example, when you're negotiating kind of audit provisions with your service provider, and they say, well, you can't audit us because the data's held in AWS, and we just that's just not a facility. But the security's robust, so you don't need to worry. Okay, that's fine. If that means at that level of the kind of the tech stack you can't audit it, okay, but what are you doing as the service provider, and can I audit you, just to kind of watch out for that kind of that cloud washing, as they say?
Okay. So one other cloud question about duration of cloud contracts. So very often businesses have long-term requirements. Keep your financial records for 6 years, but you might even have, if you're a bank, you have to keep your customer records for 5 years after the termination of the customer relationship under European anti-money laundering. So that could be 40-year mortgage plus 5 years. So you've got these long-term requirements, and then the cloud service providers won't sell you a contract, say, longer than a year or maybe 2 years or to push. Are you feeling that there's going to be anything coming from either legislation or from commercial practice that will actually allow customers to align their long-term needs for systems and services to handle their life cycles with the cloud service providers? Its view is like, well, we don't want to enter long-term contracts because we want to be able to change. We want to be able to do things differently. We'd quite like to withdraw a service in a year's time or 2 years' time. And that's one of the sort of, I suppose, big challenges organizations face is, how can we buy something that meets our business needs and the market doesn't offer something that meets your business needs?
Yeah. No, it's a really good point, Peter. Once again, might have something to kind of add. So yeah, there is no easy answer. Those are questions that will need to be thought about and addressed as part of the kind of procurement strategy. Do you have a mechanism for extracting your data in a way that is satisfactory to you? If something kind of commercially like that happens, that the provider just says, change their mind, or equally in the kind of adverse circumstances, something goes wrong, but just to make sure you have those kind of contingency measures, in place, even if that means, additional inconvenience, potentially additional expense. But yes, that's something which may need to be considered.
I'm going to comment on that. I'll comment, Jason, went to your first question. The ICO repeatedly encourages, particularly small and medium-sized businesses, to adopt cloud, and they do that because these hyperscale organizations, the ICO's position is that they're more likely to have better security in place. It's not without its issues in terms of, things like settings and what have you changing. And certainly when we're dealing with incidents, one of the problems that we find is that often people don't keep on top of the settings for different things. They might assume that things are being backed up because their documents are on the cloud. They're not necessarily, and you need to have those backups in place. And again, just various other settings as well that they just people haven't been monitoring, in terms of like how regular backups are, that sort of thing. So it's not without its issues as well. But certainly the ICO's position is, as I say, primarily for small and medium-sized businesses, they are pushing people still to use cloud and to use some of the big providers.
No more questions online, I take it.
No more questions. No, it's all good.
Or do you want me?
Should we just give it a moment in case anyone online has a question? And it's an interesting point you raise, and you often think about, as a consumer of cloud service provider, particularly the hyperscales, even the enterprise is now at a consumer level, so they can't negotiate directly with the cloud service provider. The negotiation tends to happen at the state or the regulator level on behalf of an industry or on behalf of a country, where the state says, no, you can't do that anymore. We're not going to allow you to operate in our jurisdiction doing these things anymore. We'll shut you down. But that's pretty much all they will respond to. If individual companies, doesn't really matter how big they are, go to them and complain, they'll just say, well, sorry, that's the service. Take it or leave it. And absolutely, it's entirely down to the consumer, the enterprise, the organization, to make sure that they've covered all of their essential controls, things like backups. No more questions coming in online at the moment, so thank you. I think we're probably good to start closing down.
Yeah, close down. Do you want to do it? Or-
No, you do. You go ahead. Yeah, you've organised.
Well,
Brilliant.
I have to say, thank you, because the crystal ball is definitely not there. We got to look at the way ahead. And lots of nice questions tonight. I know Tim's sure that you were confronted there, but and some of our colleagues online. But it is an area that is often overlooked. And certainly I was at another presentation recently about DORA, etc. And they put the timeline, and there was lots of people in the room, timeline down in their diaries. So it's an interesting one, because often these things are overlooked. They know it's coming, but we don't know what to do and when it's going to be regulatory control. So thank you so much for the landscape. There's no doubt that we'll be asking you back to tell us what's happening with the landscape. But on behalf of everybody here and online, which will probably be doing virtual claps, but thank you very much. It's been most enjoyable from my point of view. I enjoy this sort of thing, and it's not technical, so everybody understands that there's other things rather than the technical side. So thank you very much.